Hey guys, this is going to be a quick one. We have a little bit of an update on the settlement between Blake Lively and Wayfarer Studios, and this pertains to the 47.1 motion, which a lot of people know as a California Me Too law, which is meant to protect survivors from retaliatory lawsuits. So if somebody comes forward with accusations of abuse or harassment or such, it's supposed to protect them from, like the sort of financial turmoil of a retaliatory lawsuit by the person they're accusing. However, people have argued about whether or not that's even constitutional because you have a right to defend yourself in court. And maybe we'll, see them talk about this a little bit more. But apparently, the 47.1 motion is still on the table. That was something they did not come to an agreement on in the settlement. So I'll read this to you in a second. We have a letter, which is a notice of the settlement, and then another letter from Blake Lively's attorneys asking for an opportunity to, give some more or write another letter regarding the 47.1 motion, since so much has happened since they filed it. Give me 1 second here, guys. So the case is settled. Let me read you the notice of settlement first. 1 sec. Fix that. This kind of reads as the parties, they settled the merits of the case, right, before the trial. Didn't want the risk that came with litigation, but now she wants the optics and the financial benefits of winning in court, anyways. So I don't really know if this is going to go super well for her. I know this was unsettling to me when I first glanced at it, but I think it's going to be an uphill battle for her. So I'm not sure it's going to work out in her favor, but I'll let you guys decide what you think. Okay, you can read that. It says, pursuant to a settlement agreement and through their undersigned counsel, Blake Lively on the one hand and Wayfarer Studios, and then all the Wayfarer parties on the other hand, hereby stipulate and agree as follows with respect to the above captioned action. And then it says, 1, the stipulating parties hereby irrevocably waive any appeal of any orders in the consolidated action, including without limitation any appeal by the Wayfarer parties of the order on the motion to dismiss. So that's their lawsuit that was dismissed by the judge last June. So that was almost a year ago. So they will not be appealing that. Then the second one says, notwithstanding anything herein to the contrary, the stipulating parties acknowledge and agree that Blake Lively does not release and retains all claims, rights, and remedies in connection with her pending motion for attorney's fees, treble damages, and punitive damages under California Civil Code Section 47.1 in the Wayfarer action. The stipulating parties agree that the 47.1 motion is not withdrawn and remains pending before this court. The stipulating parties further agree that they hereby irrevocably waive any appeal from the court's determination of the 47.1 motion. So if she wins this motion, I think they're saying we waive our right to appeal, which is something that I wasn't in love with, but I have no idea what went on behind the scenes and what it took to get this settlement to happen. So the Lively action is dismissed with prejudice as between the stipulating parties. And then so that means she cannot bring these claims against them again. Okay, and that was dated May 7th. That's today. I guess they finally signed it this morning. But let me show you this other letter. And this is going to detail why they're asking for a chance to, I think, brief the court further on this. And somebody in the comments here is kind of saying what I was thinking. If your claim of sexual harassment is thrown out, then she should not have the protection because her claims did not meet the criteria. Listen, I think it would be kind of ridiculous if this motion got granted. They're also asking a New York judge to be the first person to make a major ruling on this California law. I don't know. This is, like I said, this feels like a really uphill battle. And then I also had asked Britt to weigh in on it because it was like, this feels like I don't love this. And she said, hang on, it will be hard for her to prove her 47.1 claim when there's no evidence taken about malice. She has to prove Wayfarer's intent. Intent in the law is almost never proved through circumstantial evidence. And so Wayfarer, of course, maintains that she made her claims with malice. And so why should she be awarded treble damages on a sexual harassment protection statute? But yeah. Give me 1 second. Okay. As the court is aware, plaintiff and consolidated defendant Blake Lively on the one hand and blah, blah, blah. Okay, I don't need to read all that. As reflected in the notice of settlement and joint stipulation filed earlier today, the parties have fully and finally resolved all claims in the consolidated action except one. So they agreed on everything except for this one issue. The only remaining claim is Ms. Lively's claim for attorney's fees and costs, compensatory damage, which is automatically tripled by this 47.1 statute, and punitive damages under California Civil Code section 47.1, which the parties have submitted to this court to adjudicate with no right of appeal. Okay. Section 47.1 imposes severe and mandatory penalties against any party who files unsuccessful retaliatory defamation actions against sexual harassment and retaliation complainants. So the problem here is, to me, the immediate problem is nobody ever said or agreed that this was a retaliatory lawsuit. And then also nobody agreed that she was sexually harassed. Her sexual harassment claims were thrown out. Okay. Under section 47.1, any communication made by an individual without malice, which is an important thing there, regarding an incident of sexual assault, harassment, or discrimination, including retaliation, is privileged so long as the speaker has or at any time had a reasonable basis to file a complaint of sexual assault, harassment, or discrimination, whether the complaint is or was filed or not. Okay. So again, the problem there being without malice, you have to assume that she didn't make this claim with any malice, which I obviously disagree with. I think that she definitely did. And that's something that was never, they didn't want to litigate that at the trial. So I think it would be really weird for the court to decide now that they should totally rule in her favor on that when she was basically conceding, saying, no, we want to settle this case. All right. Section 47.1 was designed to ensure that individuals subjected to sexual harassment or retaliation, and she just settled this case and also had 10 of her claims thrown out in regards to the sexual harassment. So can share their experiences with courts, agencies, the press, and others without fear of suit. I noticed what's not included in section 47.1 is making shit up. So, yeah. The California legislature enacted this privilege to provide a clear, unambiguous pathway to justice for victims of sexual assault, harassment, and discrimination. Okay. Specifically, the California legislature intended for section 47.1 to deter litigation that would otherwise force survivors to defend against a long and expensive retaliatory defamation lawsuit by imposing significant remedies for successful defendants in defamation claims. Okay. Moreover, because section 47.1 protects victims from the litigation itself, these remedies must be available at the earliest stage, typically through a motion to dismiss, to protect survivors from a punishing, protracted legal process. And this is a lot of people have been arguing back and forth since the beginning of all this. Is this even a constitutional law? Okay. Consistent with section 47.1 stated purpose, Ms. Lively respectfully requests that her motion be resolved as promptly as possible. Okay. So the thing is, she hasn't proven any of this. She didn't go in front of the jury. No verdict was reached. She decided that she was done with this and she wanted to settle the case. So again, I think on its face, if you take their word for it and you just read this letter and you're like, okay, yeah, this sounds terrible for Wayfarer. Now we're pissed. Okay. I can't speak for anybody else, but I know better than to just take her attorney's word for anything. They, straight up lied to the court about what happened when they tried to subpoena me. So I don't buy it. And also, like I said, it's really odd to, say you don't want to go to court with this and that this is settled, and then to try to also squeeze out the social and financial benefits of getting a ruling in your favor at the same time. I don't think it's going to work. That's just me. It's not impossible, and I'm not a lawyer, so of course we're going to hear from other people, I'm sure, throughout the day who will tell you, sort of the ins and outs of the actual law here. But I'm just telling you as a bystander, as most people who follow this lawsuit are not attorneys. So I'll tell you what it looks like from a bystander's point of view, at least mine. It looks like bullshit. So I don't really think it's going to go super well. All right. I could be wrong. And if I am, then that would suck because I feel like it would be terrible for them to have to pay her after she did all this. I mean, she just settled her case after it was revealed to the public that she may have perjured herself. So, all right. No doubt remains that the Wayfarer Party suit is the prototypical suit that the California legislature intended to short circuit by enacting Section 47.1. There's a lot of doubt that remains. So, the alleged defamatory statements that form the basis of the Wayfarer Party's retaliatory lawsuit satisfy all elements of privilege under Section 47.1 for reasons that have already been raised to this court. Thus, as the prevailing defendant, Ms. Lively is entitled not just to attorney's fees and costs, but also to compensatory damages, tripled, and punitive damages. So a lot of what their lawsuit, the Wayfarer Party's lawsuit, was dismissed on was, pleading deficiencies. It was litigation privilege. So Ms. Lively's, statements, as ridiculous, overblown, and dishonest as they may have been, were unfortunately protected by things like the fair report privilege and the litigation privilege. When it came to Lively in the New York Times, they couldn't be punished for that. There are protections in what you say in a court document and what reporters can say about the court document. So there was no finding that this was definitely retaliatory and that nothing they said was true. There was never a finding of that. They're overblowing it. So, one sec. Somebody says this makes no sense. I'm not a lawyer. This is wrong. This is all optics. This is a PR thing. This is a PR thing. She wants like I said, she wants the benefits of settling the case and not going in front of the jury, but also wants the headlines. So, okay. The alleged defamatory statements that form the basis, satisfy all elements of privilege for reasons that have already been raised to this court. Thus, as the prevailing defendant, Ms. Lively is entitled not just to attorney's fees and costs, but also to compensatory damages, tripled, and punitive damages. The parties briefed this issue previously, with said briefing completed as of September 29th, 2025. Those briefs included proposed procedures for determining the damages, attorney's fees, and costs to which Ms. Lively is entitled. Because the factual record has developed further since that time, a lot further, up to the eve of trial in Lively v. Wayfarer, Ms. Lively respectfully requests leave to file a short supplemental brief of 5 pages or fewer to address any impact of the court's intervening rulings since the 47.1 motion was filed. The intervening rulings, such as 10 of her 13 claims, including all sexual harassment-related claims, being dismissed, but we don't need to specify, right? And to propose procedures for adjudicating the compensatory and punitive damages, attorney's fees, and cost issues in light of these developments. Okay. Ms. Lively respectfully requests that any such brief be submitted by no later than 7 days of the court granting leave. Okay. So we'll have to see what the judge says about that. I mean, I assume he'll let them do that. I'm not positive, but I assume. So. This law equals Ezra's baby. Well, Ezra should hire a nanny for this baby because I'm not even going to go there. All right. They have some footnotes here. One of them says, first, Ms. Lively's statements were communications related to an incident of sexual harassment, retaliation, and aiding and abetting the same, and in fact were made within another privileged communication, her administrative complaint before the CCRD, which was reported in yet another privileged communication, an article by the New York Times. Like, this was all a setup because they knew they couldn't be sued for defamatory statements they made, like I said, in a legal document, the CCRD complaints. And then the New York Times was protected by, their reporting privilege. So, second, Ms. Lively made the statements at issue without malice. No one agreed to that. Or as the Wayfarer parties acknowledged, because she genuinely believes she's right. Your Honor, she is seriously delusional. She is seriously delusional, okay? Please give her money. Okay. The third, Miss Lively plainly had a reasonable basis to file a complaint or complain generally, as she in fact did in multiple ways to multiple people and to the CRD. Fourth, several of the Wayfarer parties agreed to stipulate that Miss Lively engaged in a protected activity which encompasses the element of a good faith, reasonable belief that she complained of or opposed unlawful harassment. They said for trial purposes only they would agree to stipulate to that. You're not going to use that now. They didn't agree that it actually happened. They said for trial purposes only we will stipulate to this, that the jury should presume that this happened. Okay, but they didn't actually say, yeah, we did it. We did everything that she's accusing us of. We agree with everything that she's saying. Like, that's not what happened. And this is bullshit. Again, I don't know how this is going to play out law-wise. I think you should listen to the attorneys who cover this case and people who are more knowledgeable about these kinds of procedures. But, dude, this is a press play, if you ask me. Like, she won't let it go. She could have just like gone to the Met Gala in her, dress or whatever, and then gone off to live her life. And she, as far as I can tell from the interviews I've heard, there's no NDA in place, so she could even tell her side of the story, maybe. But she just can't let this go. And again, I don't see this going. I don't see this going super well for her as far as like getting the ruling that she wants. All right. Well, guys, that's all I got for now. I got to get to work, so I'll be seeing you all soon. Don't forget to hit the like button for me because that helps me out a lot. And if you missed it, I will be saving as promised, I'll save the money from the fundraiser that I was going to use to cover this trial for the Jones trial. So I still intend to do that. Hopefully that'll, I don't know if that one will settle as well, but as far as I know right now, they're definitely moving forward with it. From what I can tell, I haven't heard them say anything about settling in their interviews or Brian's interviews. Jenna Balby, thank you for the $10. I'd be surprised if she wins. Punitives are to make an example out of someone for egregious behavior. They tried to rectify and did by her statements. If anyone should be awarded punitives, it's Baldoni. Okay. Thank you. Appreciate that. And no, I agree. She obviously, like, her issues were obviously and clearly resolved. So, well, I mean, she still has issues, but you know what I mean. Like the issues she raised in that meeting where they screamed at people. All right. Thanks, everyone. Talk to you later.